Good afternoon, ladies and gentlemen. Welcome to the very first of the Business Council of Westchester's Business Resource Center webinars. My name is Marcia Gordon. I'm the President and CEO of the Business Council of Westchester. We are Westchester County's business membership organization dedicated to economic development, to business growth, and to business advocacy for the entire business sector in Westchester. We welcome everyone. We are also a regional organization, and so our reach extends past Westchester, and we welcome everyone to this very first webinar of our Business Resource Center, which is about a topic that many businesses have asked me about and reached out to us. And so we're very pleased to have this very first webinar be on business interruption and COVID-19, coverage implications and future outcomes. And we have two experts on with us. Before I turn it over to them, I do want to say that if anyone listening is interested in putting on a webinar such as this, please contact us at the Business Council of Westchester. Our website is thebcw.org. Amanda DePalma, our Vice President, will be happy to talk to you about this. So, and we are also on Facebook Live today, and we also will have this webinar living live in our Business Resource Center at the Business Council of Westchester. So it's my pleasure to introduce our speakers. John Gover, Risk Manager of ACBI Insurance, as well as Gerald Jimo, Senior Partner of Halloran Sage, and they are the experts. They will take it from here. They will be taking questions in our chat room, so please pose your questions in the questions and answers. And gentlemen, thank you so much for being our experts today and educating our members. So John and Gerald, enjoy. Thank you.
Well, thank you, Marcia, for that introduction, and a special thank you to all you and all your team for setting this up for us. I'm going to go ahead and share my screen. We hope everyone on the line is healthy, safe, and to all the mothers on the phone, I hope you had a great day yesterday. The COVID-19 epidemic has affected all of us in different ways. The tri-state economy has effectively been shut down, and organizations have seen revenues diminish overnight. This has resulted in businesses asking one key question: will my insurance cover this business interruption? Today, we are going to take a deeper dive into that very question. However, before we get started, I'd like to officially introduce myself and ACBI to the folks on the phone who may not know us. My name is John Gover, and I'm one of the Senior Risk Managers for ACBI Insurance, responsible for growing our presence in the Westchester County area. ACBI is headquartered in Shelton, Connecticut, and is one of the largest independent family-owned brokerages throughout the tri-state area. Our business is focused on three main buckets: employee benefits, commercial property and casualty, and individual property and casualty consulting. We have clients from coast to coast, and about 50% of our business is in the greater New York City area. I am also joined by a colleague of mine, Jerry Jimo from Halloran Sage. Jerry, would you mind introducing yourself?
Thanks, John. I'm an attorney at the law firm Halloran Sage. We have offices in Westport, Connecticut, Danbury, New Haven, Hartford, and Washington, D.C. I've been practicing for 25 years, and I have represented both policyholders and carriers on coverage issues. I'm looking forward to this today because this is breaking news. This is unfolding before our eyes, and I have found that most businesses have the same questions. I'm not sure we're going to be able to give you any definitive answers today, but I hope that we can clarify, educate a little bit, and there's an opportunity to ask questions at the end. And I look forward to that. Thanks.
Thanks, Jerry. So let's go ahead and get into what we're going to cover today. I'm going to start off talking about what is business interruption insurance, then transition into the pandemic and virus exclusion that so many of us on the phone are finding that's within this business interruption. From there, I'm going to transition over to Jerry, where he's going to talk about some of the court and legislative challenges that we're seeing unfolding, to Jerry's point, daily, and speculate on some of the prospective outcomes that could happen within the next few months and even the next couple of years. And lastly, we'll stop and we'll have some time for some Q&A. We'll try and get into as many questions as we possibly can within the time allotted. And if there are questions that we do not get a chance to get to, either Jerry or myself will follow up personally within the next few days. So what is business interruption insurance? Business interruption insurance is a component of any property insurance policy that compensates for loss of income. It can cover for operating expenses, can also pay through some other parts for moves to temporary locations, new equipment, anything to help remediate that loss of income. Where does business interruption insurance typically respond? Business interruptions or business operations need to be halted by a direct physical loss, fire, hurricane, flood, any peril that can be easily predicted through modeling and underwriting. The key to this is these are typically secluded events. Every building, every region, every building in the country isn't on fire at once. Hurricanes are regional events. Floods are regional events. So let's talk about today's environment. In today's environment, businesses are shut down and are looking to insurance policies now to provide coverage for this lost revenue. The majority of these policies that we're finding today reflect exclusions for viruses, pandemics, and other disease-related matters. Now, why are pandemics excluded? After some of the outbreaks within the mid to early 2000s, SARS, swine flu, many insurers added virus pandemic exclusions to their business interruption policies. Pandemics are widespread, as we're finding out today. They're not contained like a fire, flood, hurricane, and there's a very limited pool to share the risk, one of the fundamental concepts of insurance, because everyone is impacted. Like, here's the thing. There's a lot of noise developing in the marketplace on this exclusion, and ultimately, things could change based on what Jerry's going to talk about today. We advise all of our clients that if they feel their business has been impacted, file a claim. As Jerry's going to explain in the next few slides, there are significant legislative and regulatory forces that are at play, and filing a claim starts that trail for our clients, if anything would change. Jerry, want to shed some light on what you're seeing in the marketplace?
Shedding light on this, I feel like it's having a flashlight, in a cavernous dungeon. You will see news articles. You're going to see lawsuits filed, and you're going to hear from, or at least I've been following this every day. I see articles published on this topic daily, and I would give you this warning first. There are reasons certain people are writing articles on this, and find out who the author is and who they think their audience is, because I have read countless expert articles about why this is just not covered. I've also read expert articles on why there are so many paths to recovery and coverage here. this is an exploding area. And so you've got attorneys who want to represent insurance companies writing pieces about why there's no coverage, and you've got attorneys who want to represent policyholders explaining why it's so clear that there's coverage. As a basic tenet, if insurance law or contract law for that matter were black and white, I would not have a job. Ambiguity and nuance are what courts hang their hat on. And the bottom line answer is it's going to depend. And there are indeed some arguments here. There is a lot of variation around the country regarding how policies are interpreted and also how coverages are written. So there is no one size that fits all for us. I know today that most of the folks are in New Jersey, New York, and Connecticut. And so I will try to tailor this to you. To start, you got to ask, is it worth bringing a coverage claim? And to echo John's remarks, it's certainly worth it and there's nothing to lose. Understand that insurance law is generally a state-governed concept. Every state is going to have its own regulations for insurance companies as to what they can, what they can't do, what they could exclude. That is a challenge when trying to give a generic discussion about this. That being said, there is a principle of contract law that affects insurance policies across the board. Generally speaking, all of your insurance contracts are going to be documents that were drafted by the insurance company. People don't get to wordsmith their policies and ask for a change in paragraph 5 and such. As a result, the standard of review for a court in determining whether something is covered or not says any ambiguity is going to be interpreted against the person or the party that drafted the contract. That's a key fundamental point from which litigation starts to make a little bit more sense. This is a favorable standard of review for policyholders. Therefore, what attorneys who are representing policyholders strive for is finding ambiguity. If we can take the language and say, what does direct physical loss really mean? And convince a judge that it's not clear as that policy defines it, or maybe the policy doesn't define it at all, then you get a win. So there's incentive to try to shake the tree and see what you can do. However, the stakes for the insurance industry to cover COVID-related claims under business interruption are catastrophic. They are going to fight this. And, in my 25 plus years of doing coverage litigation, I've never seen anything like this. And I don't think we ever will, at least in my lifetime. And I have not lived through any wars that were fought domestically, or at least close to home. So what's happening? Well, there are hundreds now of lawsuits that have been filed across the country on behalf of both policyholders and insurers saying, we've lost money, we've lost business, we have business interruption insurance, and you've got to cover this. Like many insurance coverages, and I mean no disrespect to brokers out there, these titles can be misleading. It's like all risk. I've got all risk coverage, which means any risk, I experience, I'm covered. Well, no, you've got insurance for all the risks that your insurance company has agreed to cover, not all risks. And the same is true with business interruption. I don't think there's any business out there today that has not been interrupted in some regard. So if you have business interruption insurance, you might assume that this is something your carrier is going to cover, but no, that's not the case. Here are the arguments that both carriers and policyholders are directing at each other. And the first, you've probably seen it if you've seen anything about this, is this idea that business interruption is a category of damages that's covered when you experience a physical loss or physical damage. The mantra on behalf of carriers is the COVID virus did not physically impact your business, therefore there's no coverage. And the obvious examples were if you're in a car accident and your car gets a dent, that's obviously physical damage. If a meteor comes through your roof and leaves a gaping hole, that's physical damage. But if no one's coming to your store or your workers can't work because of concerns or because of illness that they're suffering, that is not a physical loss or damage that would be covered. Kind of makes sense. Seems logical. Again, if things were that easy, though, lawyers would have nothing to do. There are areas of the country where physical loss has been expanded to include things like loss of use. Some policies might not even define physical loss, in which case, judge is interpreting what it means in that particular policy. In Ohio and the Midwest, generally speaking, cases see physical loss as what you think it means, which is some type of physical damage. Again, there's been no prior cases, obviously, involving COVID. This is all new. So I looked to examples of similar claims in the past with mold, mildew. In the Midwest, an Ohio case found that mildew on the exterior siding of a building was not a direct physical loss because it didn't impact the structure and it's capable of being wiped clean. There are cases in other parts of the country, however, that equate physical loss with loss of use. And this is the primary policyholder argument. They will say, well, look, I have a Pilates business and this space is only useful if I can teach Pilates here. And if I can't open because the town is shut down or for other reasons, I can't use this space as a Pilates studio anymore, and therefore I have experienced a physical loss. New Jersey, there's a case from 2014 that held that covered property damage occurred when ammonia was accidentally released into a facility, rendering the building unsafe until it could be aired out and cleaned. Property can sustain physical damage without experiencing structural alterations. That is the other side of the spectrum. But with that precedent, you can understand why this is not a done deal here. There is a lot to tease out. Is one of those arguments, going to win the day? Obviously, we don't know. A lot is going to depend on your individual policy. A lot's going to depend on the state where you are. Now, if you really want to get into the weeds about physical damage and viruses, one thought I have is it might depend on whether you can prove that there was physical virus in your business, meaning people contracted it, it was on a surface, and therefore there was actually a physical manifestation of the virus. That's going to help. Also, if any of you are in the hospitality or hotel industry, you might have coverage for communicable diseases. And if you can show that there is, the virus is being transmitted and contracted at your business, you might have a stronger argument there. One of the leading cases in terms of prominent cases that's been filed in the last month is in New York in federal court, and it's Thor Equities versus Factor Mutual Insurance. And some of you might know Thor Equities. They are a giant real estate company that owns hotels throughout the world and throughout the country. They have business interruption policy limits of $750 million. So they're paying significant premiums. They've had to close certain places. They've got workers who are sick in certain places, and they have filed this omnibus lawsuit in New York federal court. They have the communicable disease coverage as well. In an interesting strategy, the carrier, Factory Mutual, which is a company I'd never heard of before, they're a small insurance company out of Rhode Island. They've taken the posture that, you know, we think this is going to fall under your communicable disease coverage, which has a $1 million policy limit. It's actually kind of a smart strategy where you're not fighting the bigger argument about property damage, physical damage, which would have greater consequences across the board, and just say, you know, we're willing to concede this is a communicable disease issue, and therefore here's our $1 million and go home. To some of us, that would be a great recovery. To a company like Thor Equities, that would be a significant loss. You know, this isn't to suggest that the physical presence of the virus on your property is going to win the day, because even that might not make a difference. The big case in New Jersey right now, at least the one that has gotten the most notoriety, you might have heard, is the Benito's restaurant versus Chubb case. And, you know, they're essentially saying we can't operate for a variety of reasons. One being, you know, the government won't let us operate the way we want to. But the Benito's case is not, doesn't have all the specific details of the Thor case that give you a sense that there's ways to resolve it other than going all the way on the big questions of physical loss. And the Benito's case has been filed in an effort to become a class action so that they are representing restaurants everywhere who have policies with Chubb. If you have a chance, the lawsuit is actually, you know, online, and the lawsuit quotes Oscar Wilde and Anthony Bourdain on the topic of why restaurants are so important to our culture and things like that. It's actually pretty funny. But that's a much more difficult case to pursue because a class action presumes that everyone with Chubb has the same policy, and they presume that they're governed by the same state laws, which they aren't. I think it's a much harder row for you as a policyholder to make this a bigger national issue rather than focus on the specific language of your policy in your state. Some policyholder arguments have relied on what I would describe as the use of science argument. And I'll try to think of some examples for you to explain this. This is kind of like what we spoke of earlier with, the virus is indeed a physical thing. It takes up space. It's not, it might be invisible, but it's a real thing, and it really infests the body. And we're not talking about, this amorphous thing. And sometimes that works, as technology has changed, we can further define terms in ways that we couldn't before. Generally speaking, courts will look to what the intent of the carrier was. If the carrier says we do not cover emotional distress claims under our bodily injury provisions, then, emotional distress isn't covered. I took a case on behalf of a policyholder probably about 20 years ago to the Connecticut Supreme Court on the issue of whether the physical manifestations of anxiety constitute a bodily injury. And there's plenty of science on that. It didn't fly. But that argument did fly in other states. So it's out there. And you'll see folks talk about the physical loss and damage that a virus can do. I don't have a lot of faith in that argument personally, but it's out there. In California, there are a slew of cases that have been brought by so-called celebrity chefs, and that they are arguing that. They're saying our restaurants are, in fact, been coated in something that prevents them from operating. And a restaurant is probably the best example of making that scientific argument, because people are actually, putting stuff in their mouths at your business. But, again, it's hit or miss. And it's an interesting argument. We'll see how it plays out. Second, and again, I'm trying my best to condense this because it's about a semester's worth of a law school class to talk about. Second is the virus exclusion. And after, I think it was SARS in 2006, the insurance industry adopted forms that excluded damages caused by virus. Not every company put it in there, and not every exclusion actually follows the same form. So those are red flags for policyholders to say, hey, maybe there's an ambiguity about what we're doing here. On one level, the argument under the virus exclusion is there's a difference between if you had a flood and it damaged your business and it created mold, and as a result of the mold, people got sick, that might be covered because it's actually a consequence of a physical loss, as opposed to a business that is structurally sound and people got sick inside from it. That's the type of virus coverage the insurance industry really intended to exclude. But there's plenty of wiggle room and I've seen some of these arguments be made in the pending lawsuits. One is, anytime a major change in your coverage happens, your insurer's got to provide you notice of it. Most of us get a premium renewal, we pay it, and we don't really pay attention to all the fine print. And maybe you never got actual notice that a virus exclusion was put into your policy. There's an argument for why it wouldn't apply. Maybe your policy doesn't have this virus exclusion, and the carrier says, well, we've always excluded that because there's no physical loss, physical damage. There's an argument now to say, well, you had the opportunity to put in this exclusion, and the absence of it shows that it is included. Or maybe that's enough to say there's an ambiguity, and you interpret it against the policy, the carrier, and you win. Again, you've got to look at your own policies. For a reason I don't yet know, there's a federal case pending in Connecticut, the Hartford versus Moda, and Moda is a high fashion shoe company, and it's a deck action about whether Moda has coverage. And the Hartford, in their lawsuit, which asks the court to determine there's no coverage, points out that their virus exclusion language is different in New York than it is for the rest of the country. There's probably a regulation in New York that required tweaks that other states don't have. That's something that's going to need more research. But if you are a New York business and you have a virus exclusion, someone should take a look at that specific provision and not rely on, a newspaper article that says this is how virus exclusions work. And then the last major argument is what's called the civil authority coverage. And that is, if your business has been physically shuttered because the mayor or the governor has padlocked it, or people can't access your business because of a civil order that prevents physical entry, that's something that is covered. It's a pretty logical, low-hanging fruit kind of argument to say, hey, our business is suffering precisely because the governor has told us we can't be open. Unfortunately, the civil authority coverage relies on the very same physical loss language. If you have been closed down because of a physical loss, either to your building or to someone else's building that prevents access, 9 times out of 10, you're going to be covered. But the civil authority argument really ends up being in the same place as the physical loss argument. It relies on the same thing. Moreover, it's a little bit trickier than the other arguments because there has been no consistent civil authority orders. Every state, in fact, every town seems to have slightly different regulations and such. And what if you're a restaurant that is told you can sell meals to go only? Are you in the same position as a hair salon who's been told you can't operate at all? It's a little bit stickier, and so I don't think it's going to be the area that wins the day, one way or the other. And if you think about Thor Equities, the New York case, there's a company that's got business and properties everywhere. Every variation of having no civil order to having a very strict civil order in Italy. is going to apply. That being said, there are judges who understand coverage stuff. And I found an order in Texas, this is March 31st of this year, that a county judge gave an order that, quote, the COVID-19 virus causes property loss and damage due to its ability to attach to surfaces for prolonged periods of time. Therefore, the court cannot do business. And so what the judge has done is explicitly tie in the closure of business to words that are generally found in your policy. So the judge has said, hey, you know, you want to rely on some facts that are going to give you coverage, here they are. If we lived in that county, we'd be in very good shape as a policyholder. But again, that appears to be a rare example. How are we doing with time? Okay, legislation. There is legislation being debated and proposed in dozens of states. Some of it is pie in the sky, and some of it is unlikely to pass. Generally speaking, politicians are under pressure to do something. And if they see that carriers are not going to cover this, they want to pass a law that says carriers have to cover this. Two things to understand. One, when a legislature passes a law that says going backwards, this contract language shall be interpreted this way, it impacts all hosts of constitutional law issues and common law contract issues that say you can't tell two private parties after they've bargained what their bargain means now. You could make prospective legislation dealing with in the future, if you're going to offer business interruption, it shall include this. At least with that, carriers can get their actuaries and underwriters together and figure out how do they provide for it. And your premiums are going to reflect that change. But the legislation you've seen that attempts to act retroactively is legislation that I feel is never going to fly. And if it's passed, it gets challenged. Even that has some exceptions to the rule. There are examples of ex post facto legislation that has been held up in the context of emergencies and things like that. New York, there is a bill currently I identify as AB 10327. It's a bill that retroactively mandates coverage for COVID-19 businesses, COVID-19 business interruption, but only for businesses engaged in certain human services and community-based health providers as defined by the bill. That limitation might make it survive because it's directed to these kind of emergency conditions. In New Jersey, there's a bill that would require carriers to provide that type of coverage for businesses with fewer than 100 employees that already have business interruption coverage, even though they might have exclusions for virus. It's not yet a law, obviously, and it's pending there, but that's one to keep an eye out for. At the federal level, Congress has some legislation that they are debating to try to kick in, similar to what they did after 9/11 with terrorism insurance. And the key to the prospective legislation, again, is carriers can figure out how to underwrite for it, but also the government is often the backstop, saying that they will reinsure these carriers to handle taking on this extra coverage. Generally speaking, legislation, just like the courts, they seem to give you we need to fix this now, immediate relief. And in truth, none of this is going to provide immediate relief, because the path which both legislation and cases have to follow is long. So this probably, we could go to the third, looking prospectively. The stakes are so incredibly high for all the parties involved that I think we can be assured this is going to be kicking around for a long time. It's not a coincidence that some of the high-profile lawsuits looking for coverage have these celebrity chefs as lead plaintiffs. There is a concerted effort amongst the policyholder attorneys to make this to make the policyholders the good guys in this, people you like, people you want to fight for. I've seen a lot of things in 25 years, and usually, the strongest language is reserved for murder cases and, political rivals. But I found a quote. There's a suit pending in Pennsylvania, one of the first ones filed. A law firm brought in its own name to get coverage for business interruption. And this is what the firm put out as a press release. Travelers Insurance, after cashing our premium checks for years, decided yesterday that instead of paying our business interruption claim, they would hire a large law firm and sue us in federal court instead. Apparently, their way of adapting to a pandemic is filing lawsuits against their own insureds, and we welcome the opportunity to fight on behalf of small businesses against rank corporate greed and their legal enablers. I've never seen language like that in a coverage case, but it shows you why the stakes are high. Now, on the other side, carriers are trying to get out ahead of this as well. In Chubb's most recent earnings call in March, the CEO was quoted as saying, flatly, business interruption does not cover COVID-19. And based on what I talked to you about already today, you realize that it's not that easy and they're impossible to make a general statement. But for the CEO to say that is telling you that they're trying to set the tone and send the message. And he also said in that call, the industry will fight this tooth and nail. Pretty harsh words for a coverage case. The National Association of Mutual Insurance Companies is on record writing to Congress, telling them, don't make us cover this. There was a report in the New York Times that the CEO of several large insurance companies had a direct phone call with President Trump about this. And the very next day at a press conference, the president said something to the effect of, yeah, I understand it's a complicated issue and people might not be covered for this. So both sides are fighting to get their story in the paper, get the headline. With regard to litigation, these suits are not going to be resolved this year. They're not going to be resolved next year. They're going to go to trial. They're going to be appealed to the Supreme Court of the particular state. The lifespan of a coverage case like this is probably 4 years. So if anyone's suggesting to you that the quick fix is to bring litigation and see what happens, they're wrong. You're going to have to survive this while these issues are pending, and perhaps there's some remedial help afterwards. But unless you are a very large company or a very well-to-do restaurant chain, this is going to be a long road that's not going to keep you afloat in the short term. Last thought on prospective is I read in the Insurance Law Journal of May 7th last week that some studies were done, and the broad question of, can the insurance industry survive this if they are forced to cover it? And I found it interesting that this particular journal said that financially it could be a wash because, for instance, just in the UK and United States alone, they're projecting a $51 billion reduction in claims, costs, and payments because of the quarantining. People aren't driving. People aren't, going to the mall, slipping and falling and such like that. A massive windfall, even if policy premiums are being refunded to a certain extent, compared to about the same amount of money that they'd incur if somehow coverage was required of them for the virus. So, one of the arguments is we can't put this all on the insurance industry. It's not so clear. Hopefully, what John and I have talked to you about today demonstrates why there is no easy answer to this, and why this is not going to be resolved anytime soon. But you have nothing to lose by making the claim and looking at your own particular policy and see how it lines up. Let me see if there's one question there.
Thank you, Jerry, for that. I encourage everyone to, we've got some time before the top of the hour. I encourage you to use the question bar in the chat box from a question standpoint. I've got one so far. Our insurance broker says our policy only covers physical impact / damage to our building or property, even though COVID-19 has interrupted our not-for-profit ministry. Is there any way to get around this? To the person on the phone asking this question, how we've been advising all of our clients is to what I alluded to in the first thing: file the claim, because ultimately there is so much unknown that is going on, as alluded to Jerry and I's discussion over the last hour, that it's going to be up to the carriers and eventually down the line the legislative bodies to make these reactions and to make these decisions. So I would suggest you file it. We always err on the side of file the claim and let the carriers make the decision.
Yeah, I concur, and just would also add that, you read the policy and it says there must be direct physical loss or impact. What that actually means, though, is up for some debate depending on where you are. So it might be worth the challenge. Force majeure clauses in third-party contracts. Well, that's a whole other topic instead of cases that are out there. But in fact, yes, there are contracts that cannot be fulfilled, a business that can't be done because of this, and as a result, some people are getting sued for delays or such because they've not fulfilled their part of the contract. And if you have a force majeure provision, which roughly translates to, an act of God that prohibits you from completing the contract. That is an excuse and a good defense to breach a contract. There's definitely a force majeure issue. And the reason why I believe it's a successful argument is because everybody has been hit with this, both sides of the contract. Maybe the goods didn't get delivered, but the place they're getting delivered to is a store that can't open. So I think there's going to be more uniformity on the resolution of those issues in the force majeure realm than they're going to be on the coverage issues.
I see another one that came through. Liability concerns surrounding employers who have employees that contract COVID. I think this is this is another issue that's very complex and we're going to see be unpacked through the court systems as a lot of the country goes back online and comes back to work. I think there's a lot of things at play. One, you look at the industry, so what the inherent exposure is to COVID-19. A restaurant is going to have a different exposure from a liability perspective as opposed to a standard office. So that's going to be that's a factor. And two, not just on an employer liability, but from a workers' comp perspective, that's another issue that's going to slowly be unpacked throughout these next few months when we all come back online. Is workers' comp cover an employee who's contracted COVID-19 while they're at work? So, I expect to see, and Jerry, feel free to jump in, some stuff come up in healthcare or any folks where you have, that inherent exposure.
It's a great question. And, at my firm, we have a workers' comp department, and this is the issue, is whether it's covered, because as a general proposition, an employer's liability to its employee for injury or illness is going to be exclusively governed by workers' comp, and workers' comp is the exclusive domain of state and statutes. So every state is going to be different on this, and we don't know. There's been no advisory opinions, and you're right. I represent a company that is in the food chain, food distribution line, and they were good up until about a week and a half ago, and suddenly one worker tested positive, and within 3 days there were 12. And overnight, this had to be addressed. And how do you do it? There's no playbook for this. But I would assume that because of the limited types of relief you get in workers' comp, meaning you don't get, pain and suffering and such, that you get a limited amount of money, that it's probably going to be covered because the risk in terms of what the ultimate payout is capped in a way.
Any other questions? I know we have a few minutes left. There was a note that came into the chat box on whether this copy, the webinar will be circulated. I will be, Jerry and myself will be sending over a copy of the presentation, as I know the BCW has recorded this, and it will be posted to their website as well as the YouTube page. So there will be both of those copies. Well, as long as I don't see any questions come back through, Marcia, I'm going to turn it back to you, ma'am.
John and Jerry, thank you so much. John, I think you could take down. Great, thank you. Thank you so much. This was extremely informative, answered many questions for me, as we at the BCW also get inquiries from our members, and we will know who the experts are to refer people to who have questions in this area. John, we see you in person at so many BCW events. It's nice to see you virtually, and thank you for introducing us to Jerry and to the expertise he brings to this as well. So we thank you all. We wanted to remind everyone that this will live live at our Business Resource Center at thebcw.org. And if I can also just remind everyone that we do have several other events coming up this week. Tomorrow with the Small Business Development Center, more information on the PPP loans. On Wednesday, we have our town hall meeting to begin to explore how we are going to reemerge, and many other things happening in the next few weeks at the Business Council of Westchester. So we thank you all for tuning in. We want to once again thank John Gover and his team at ACBI Insurance for being such a great BCW supporter and bringing this very, very important topic to our members today. And Jerry Jimo from Halloran Sage, thank you so much for your great expertise and for sharing this information afterwards. Will you please just each give your contact information again before we end? So John and Jerry.
Yeah, I can. How would you want to do that, Marcia? Because I was gonna send that out with the presentation. Would that work as well?
Sure. And why don't you just verbally give your email now?
Okay, on my email. So my email is jgover, GOVER @ACBI-INS.com.
Wonderful. And if anyone has any questions for Jerry, also, I think John is the best way to get that information to him, and you can oversee that. So thank you all. Thank you, ACBI. Thank you, Halloran Sage. Thank you, BCW members, and stay safe, stay healthy. Have a great day.